second panel, now we have with us Justice Priyan Prakash, who's a former judge of the Madras High Court. Justice Prakash has extensive experience on the criminal side, of course, especially as a prosecutor. Thanks very much, Justice Prakash, for joining us. We have with us Mr. Somesh Goyal, who's a former member of the Indian Police Service, and known for his extraordinary work in prison reforms and as Director General of Police, Himachal Pradesh. Thanks, Mr. Goyal, for joining us. We have with us Professor Dr. G.S. Bajpai, Vice Chancellor of National Law University, Delhi, also a member of the Criminal Law Reforms Committee that was set up by the Government of India back in 2020. Thanks very much, Professor Bajpai, for joining us today. We have with us Ms. Seema Joshi Arya, who's the criminal justice expert at the United Nations Office on Drugs and Crime. She has worked on the intersections of prison reforms, gender, and criminal justice reforms across many different jurisdictions. Our discussion as part of this panel is going to be more forward-looking, particularly after getting a good insight of all parts of the system from the first panel. And it's always a good time to know how the system is working and how the criminal justice system needs to be reformed. But more specifically, with the new criminal laws that have come in, with the good elements and the gaps, they've done a good job of setting the context for us. The criminal justice system, as per the new laws, is still partly colonial in nature, needs to be citizen-centric, and needs to prioritize justice over punishment. And I think that sets the tone for reforms in the criminal justice space for the 21st century. As part of this panel discussion, I would request all panelists to share their opening remarks for about 5 minutes, and then we'll keep around 30 minutes for discussion and close this with audience questions for the last maybe 10 minutes. I would request Justice Prakash to please start with his opening remarks.
Thank you. Hello. Hello. Thank you. I'm very happy to be here because the whole discussion is very sober. All of the earlier panelists were very sober, down to earth, and we are able to know not activism here, no nothing, no rhetoric. So I'll also get to business quickly. See, I'll tell you, my profile is that I was 15 years public prosecutor in the trial courts in Tamil Nadu. As a trial court public prosecutor, you have to put witnesses in the box, keep examining. Then 15 years as a defense lawyer. Then 10 years as a court judge. And now I'm working in the prisons department for reformation of prisoners. Post-retirement, I'm just working there for the reformation of prisoners. So this experience which I carry tells me a few things, like now we are engaged in this reformation of the criminal law and other things, isn't it? True, criminal law has to be there, we have to address these issues, but I would like to share with you my experience and perspective. I feel that trying to reform criminal law from the criminal law side is one part. More than that, I was sent to the US by the Supreme Court of India to study the terrorism cases. There I went to the jails there. I was told that 33% of Americans go to jail. So I came to Tamil Nadu and did a survey. In Tamil Nadu, we have 10 central prisons, 18 district jails, and 29 sub-jails. So I did a calculation on a particular day. If a head count is taken in all the prisons, both remand, convict, women, everybody, what would be? I found that 25,000 to 28,000 prisoners only will be there in all these prisons put together against a population of 8 crores. Tamil Nadu population is 7.58 crores. 25,000 people only go to jail in Tamil Nadu, which means 0.0001%. On the contrary, US 33% out of every 100 Americans, 33 go to jail. So this gave me a confidence that yes, we are dealing with a society which is essentially peaceful, essentially good people, in spite of the police, in spite of the judiciary, not because of the police and because of judiciary. I was convinced that people are really good. It's only that we are trying to criminalize them. So this thing came to me, and I thought that's something we should have to address this issue. So first thing I feel is that if you study the crime and its basis, I find that more addressing the criminal law reforms, we should address the civil law reforms. 50% of the crimes that fall out are the failure of the civil law system. The inability of the civil courts to dispose of land disputes, landlord-tenant disputes, simple contractual disputes, all this have a fallout here. I'll tell you one small example. 138 of the NA Act. It's a criminal waste. 138 of the NA Act has taken away when I came to the bar, I started my training in the magistrate's court doing 323, 324, 326 cases. 323 means hurt, grievous hurt, those cases. Now today, in no magistrate's court, 323, 324 is there. Now all courts are flooded with 138 cases and DV Act cases. What do the police do? All 324 cases are converted to 307 cases and then they go to sessions. So 138 is the biggest bane. Why? Because civil justice system had failed to deliver the goods contractually thing, and Order 21 is a bane. Order 21 CPC is the bane in the system. So I think somewhere we will have to work out addressing the civil justice system. Then of course the other laws like NDPS Act, which she was saying, and POXO cases, all this is there. Even in POXO cases, when I found that love cases are, because I used to sit in the habeas corpus bench, that is Romeo Juliet cases. Romeo Juliet cases, we find that if the girl belongs to one community and the boy is other community, or is dominant and anything, the entire texture is different. It all depends upon who is in the dominant thing. So there also the problem is not real offense, but we are criminalizing our youth by making it a thing. So one thing I was able to do as a judge was that in Tamil Nadu, we have a large scheduled tribes population in Ooty area. There the children used to get married, they used to give in marriage in 16, 18, and the girl goes to the hospital pregnant. The boy, they'll put an FIR against the husband under POXO. Because the doctor will give an intimation that this girl became pregnant when she was 17. So and police will suddenly dawn on them and arrest the boy. He will not even know why he's arrested. He is getting criminalized there. As she pointed out, one day in prison itself is enough to ruin. So what we did was, we sat to the DGP of police and we issued a circular that in all these cases, arrest can be done only on the approval of the Superintendent of Police. To that extent, we stopped this Romeo Juliet arrest in Tamil Nadu, all because we were able to sit across with the executive and get these things done. So this is one problem, which thing. Second problem is in the criminal justice system is rank perjury. From start with, as Sharath pointed out, this is the one jurisdiction where you have a police beginning with a confession is inadmissible, a statement is inadmissible, because 4 countries, Sri Lanka, India, Bangladesh and Pakistan, this is made inadmissible. So he is concocting a case. He is forced to concoct a case. There is so much of perjury in the system that I think we will have to address that issue. Only then justice will be meaningful. Until that is done, it is absolutely not meaning. When I told you about the civil cases, you will find that civil litigations are vexatious litigations in the country. This was noticed by Macaulay way back in the Law Commission report, and the first Indian Penal Code, which he drafted in 1837, he had a section 196 IPC, which said that a vexatious suit instituted would result in a punishment of 2 years imprisonment. That was deleted by Justice Barnes Peacock, and the present IPC does not have it. So this filing of civil suits and getting people caught in civil litigations is a bane in this country. So this is where also something where we have to address and see that if civil justice system is somewhat put in place, then the pressure on the criminal justice system will think. Lastly, migrant laborers problem. In places like South India, we have lot of migrant laborers from northeast region coming. They do not, Bengalis, Orissa people, they are either victims of a crime or they are accused of a crime. They are totally helpless. So what we try to do is we try to speak to the Bengali Association, Oriya Association people and tell them that at least you people go to jail, find out these boys who are not able to give bail because they do not know the language. Our police, they do not know Bengali. They do not know Tamil. So this Bengali association, Oriya association, Marathi association, all these associations, mostly migrant laborers are from the northeast and Bengal. So we try to do it and help them out that way. But ultimately these associations are already in litigations. They are fighting among themselves. Where do they have time to address these issues? So somewhere this migrant laborers thing also has to be addressed. I think these are all some of the things which I thought I could flag. And then Sharad pointed out, the public prosecutor is the bane in the system. Politically appointed fellows who come to the court with the chief minister's photograph in the packet and they just go about throwing. Their juniors will appear against them. They will sabotage the case. So we have given a report to the Supreme Court, which is there in public domain, that public prosecutors should be professional people who must be not these political appointees. But in this present BNSS, it has not been addressed at all, so this problem continues. So these are all the things I thought I could flag before you. Thank you for this opportunity.
Thank you. Thanks very much, Justice Prakash. Some very key insights there, particularly from the lens of why crimes may happen as a fallout of our issues with civil litigations and our issues with not being able to pursue those matters correctly, and very importantly, the last point on how the institution of public prosecutors needs to be looked into again. If I may move on to Mr. Goyal. Okay, we'll go to Professor Bajpai now. Professor Bajpai, from a more forward-looking approach as regards the penal policy for India in the 21st century, it would be great if you could share your opening thoughts about it.
Yeah, thank you so much. And let me begin with a very important, remark that our discussions with regard to the reforms in criminal justice systems are very, very fragmented, isolated, and very disconnected, because of one single reason, that we do not have a very coherent national criminal justice policy in this country. Therefore, we oscillate between punitive, harshness, liberal, this, that, and it is, see, the peculiarity of the fact is, we have the most liberal aspects and we have the most harshest aspects in the same law. So you give forgiveness, community service, and compounding, plea bargaining, but you also have the death penalty. So ideology of criminal justice system is a very confusing, aspect that is there. So the ideology of the criminal justice system, priorities of criminal justice system, criminalization, debates on criminal justice, what to be criminalized, what not to be criminalized. Can you believe what is the source of this decision making? It's not simply passing the bill in the parliament, but decision to criminalize has to be informed by those 7 great principles, starting from J.S. Miller. Those who are the student of criminal law, they would understand what I'm trying to say. Third is, what should be the limits of criminal sanction in a constitutional democracy? No debate. Third, which is very important, is what kind of criminal justice system? Andrew Ashworth, the noted criminal law, in England, he said a just and fair criminal justice system is an unrealistic expectation of the society. A criminal law and criminal justice system cannot be fully just, he said, because of the nature of criminal law. Because in the center of the criminal law, there is a pain and power. Criminal law is a pain delivery mechanism, so to say. Second point which I wish to make here, that the choices that you have, Herbert Packer, he said that because of the public expectation and the state choices, you end up having 2 types of criminal justice. You have to choose. Either you can have a very due process-centric criminal justice system, which is very idealistic in nature, which we often talk about, it ought to be like that. Other is a very practical criminal justice system, which follows the crime control model. So when you see the bulldozer justice coming up, this is the applied and practical criminal justice system emerging from people's expectation at times. Because people tend to force that we want the result. But are we ready to get those results at the cost of due process and constitutional values? But we have to make choices. So it's a people-driven expectation. So I am making one very interesting statement, and then I leave that thought with you, and then I'll move on something else. We think that criminal laws are the defining elements as far as the nature of criminal justice system is concerned. Sometimes criminal laws and criminal justice practices are so insulated, so seculated, because what criminal law defines is very ideal. But what you are saying and what is causing concern, it is not the product of criminal law, it is the product of criminal justice practices. So for instance, police indulgences in torture or high-handedness, it is not the part of criminal law statement. It is the part of police subculture or criminal justice subculture which generates over a period of time. So depend what kind of criminal justice system we have nurtured. So irrespective of the nature of criminal laws in the country, the criminal justice practices continue to be something else. I would say in Hindi, Nietzsche was a philosopher. He once said कि हो सकता है ये दुनिया ऊपर वाले ने बनाई होगी, लेकिन ये अभी उसके हाथ से निकल चुकी है. So you make a criminal law finally which goes beyond your hands, because you have no control, because this new criminal law will be given to the police, to the prosecutor, to the judges. How it is going to be played out in a sense is something which has no control. You cannot predict, because law never says that police to indulge in torture. So in that sense, so I always say we are too presumptive about criminal justice system, too presumptive about criminal law, because we do not know what works and what does not work. And here I would congratulate VIDHI, at least they are coming out with a lot of things in terms of empirical answers to the things. So like for instance, whether punishment deters, whether punishment does not deter, nobody knows. Whether you make a law, whether it works or does not, we leave it to the chance. You never know whether it will work. So we don't have any empirical verification of the fact whether punishment reforms or punishment changes the people. And the most important thing in criminal law is the operation of criminal law is such, which is not sort of a very creative one. It creates issues for the people, but it doesn't have a healing effect. This is the nature of criminal law. So operation of criminal law at a very large population for crime doing doesn't necessarily bring coherence in the society. Rather, it creates a lot of rifts because people are divided in the party. Now, 4 very important ingredients of the criminal justice system, that would be the testing point. So how to make criminal justice system effective and efficient, that is the main thing. So sometimes you think that harsh laws would be the answer for it. So harsh laws are not necessarily the answer, because in America, if they have the death penalty, now if you see the Martha, the former dean of Harvard Law School, she has written a book on when law should forgive. So forgiveness jurisprudence is also being discussed in the society which allows the death penalty to be retained. That's the contradiction. Criminal laws are defined by the contradiction, amazing contradictions. And second thing is the fairness that you want. So efficient, effective, fair, accountable, and transparent. But the major crisis where I would like to draw your attention is why we are actually struggling with the problems that the criminal justice system has. It is not because of the structural reason alone. There is a serious crisis of legitimacy with regard to the criminal justice system. And what is the source of this legitimacy? This legitimacy is in the mind of people, because substantive criminal law is not important, but the procedural fairness as perceived by the people is very important. And I put it like that: criminal justice places itself in a dialogical relationship with people. So criminal justice system essentially creates relationship with people. But what kind of relationship are created in the operation of criminal justice system, that would decide the fate of the criminal justice. Therefore, I say, Tyler, who wrote a book, the title of the book was When when should law, not when should law, it is about the legitimacy of law. And he is saying when people start perceiving the law to be more fair and procedurally just, they tend to follow and comply with the law more and more. So credibility of the authority as perceived by the people is a bigger thing. And we are not doing anything in that regard. And therefore the crisis of police as an institution, prosecution as an institution, judiciary institution is very important, because people's behavior with regard to the compliance of the law is hugely contingent upon the perceived legitimacy of the system. I think my time is coming, but 3 reforms I am pointing out which are very crucial and which are still to be done, and despite these laws. One is substantive victim justice and victim reforms. Lot of victim centricity is still needed, though this law has brought considerable changes and reformation. Participatory rights and other kinds of rights are very important. Second right which we should look at, the non-custodial measures. I think there is a huge scope in our criminal justice system. Despite community service being added, there are immense scope to really revision the whole idea of non-custodial measures. I'm not going into that because restorative justice and all those ideas are very important. And last, which is very important and which we couldn't touch in this reform process, is the sentencing reform. Sentencing we have forgotten. So if you want, because 23 offenses are in the mandatory punishment category as far as these crimes are. So how the sentencing options are available now before the judge, if the discretion is removed, and how the mitigating factors would be evaluated by the court in those circumstances. And sentencing is mistakenly considered to be important only in death penalty cases, as it is often discussed. But I am saying sentencing is equally important in all other cases. Huge debate and discussion is needed as far as this particular area is concerned. Thank you.
Thanks very much, Professor Bajpai. Very, very important observations. It's always great to have an academician's point of view, and it's good to hear about the more fundamental questions about, let's really think about the issue of, as we discussed in the morning, what should be the crime, how should you decide what should be a crime, and how do you punish for that crime. And of course, the very important point on sentencing, and it's not just about death penalty versus life imprisonment. It's a lot of these offenses where the range provided is very, very large. So for some offenses, it would be anything beyond 3 to life imprisonment or 7 years to life imprisonment, and that gives extensive discretion to the judges. But without any guidance as regards mitigating circumstances and aggravated circumstances, it becomes very difficult to ensure that certainty. If I can move on to Ms. Seema Joshi Arya, it'll be great to learn something from about issues of access to justice and how to really, going forward, how do we ensure that things, the troubles that we've discussed in the morning also, and throughout the first the panel discussion also, issues with regard to prisons in India, and what are the key learnings that we have that we can really take forward in the 21st century?
Yeah, thank you, Navid. So first of all, I think we all have discussed a lot about, the criminal justice system per se, and encompassing all the prisons, police, and I think Madhurima also touched a little bit on the access to justice aspect as well. So in terms of my contribution to this enriching discussion, I think I would like to just focus on mainly on 4 points, apart from what you have mentioned, particularly on access to justice, that I'll come later on. Which I would like to discuss here is about criminal justice system. The criminal justice system, of course, we do have policies, everything is there, but has been mentioned by Professor Bajpai, and in the previous session also, thank you. In the previous session also, that what is actually required is the implementation of that particular those laws, those policies which are already in place, and how do you interpret those policies, those legislations and other things, that is very important. So taking cue from what Professor Bajpai has mentioned, that that how to do it, the criminal justice in itself, the laws are there. I think what is very important is the training and the capacity building of the law enforcement officials, of the judiciary. All this is very, very important. And at the most, I think what is also required is the staff well-being. That is also one of the most important factor which we all need to focus on. I'm not going to repeat what has already been discussed in these discussions. I'm going to identify the areas which we have not yet, focused on. So I think this is also very important, and also the information, those what the laws actually interpret correctly, what the policies interpret correctly, what the guidelines are there, needs to be trickled down at the very lowest level of the law enforcement and the judiciary and for the prison officials, and they need to understand that how they have to move forward aligned with all these things. So this is one thing which I would like to say. But when we are talking about the criminal justice system, not just about the the laws and policies, another most important thing is are we as a society, because actually what is justice? Justice is meant for us, for all of us. Justice is there because it is for the betterment of the society, and we are the people who are seeking justice. So are we aware of our rights or not? That is also one of the most important issues which we need to see, because considering India's diversity and India's the population, we do have so many people, I'm sure not in this room, but otherwise we have people who are not even aware of their rights, who even doesn't know that what right do they have under the system to reach out and how to reach out to that particular system. So also to make them aware of their rights is also one of the very important aspect of having a very good criminal justice system in place in the country. Apart from that, what I would like also to mention is that we are talking about how the laws should be implemented, the police, what it needs to be done, the prosecutors, everyone's roles in judiciary. But I think it is a whole of society approach also, and we also need to see how we can prevent crime. So when in the morning I was hearing Audrey, who was talking about that in most of the cases she has handled about the, on the sexual offenses cases, they have been committed by the known people. So that means something somewhere is lacking in our society also. So we need to do a lot of crime prevention, many evidence-based prevention programs as well. We have to inculcate that into the society, and we also have to look towards that aspect to have more of counselors, as was mentioned by Professor by TIS. And apart from that, what I would also like to highlight here is the alternatives to imprisonment, which again is a very, very important issue, the non-custodial measures, which needs to be implemented at all stages of the criminal justice system, not only at the pre-trial, not just the community service at the time of sentencing, but at all stages, at pre-trial, while trial, at post-trial also, when the person is inside the prisons. And one of the important aspect, I think that, as has been mentioned earlier also, that in our prisons, most of the prisons are in our country, in many of the states, have people who use drugs. This is one of the most important, issue which needs to be considered, particularly in our country as well as globally. So in this case, I think the punitive laws, particularly in this case, they are not working. Of course, the deterrence needs to be there, and there is no defined definition as such that under which offenses there would be a deterrence and under which there would not be. However, there is enough research, there is enough evidence to show, and even within our country we can see that deterrence is not a solution to put these people behind the bars, because what they require is the rehabilitation, the counseling, and their treatment and their reintegration back into the society. So we also have to look into the offenses. We have to identify those offenses for which there is a very dire need to not have a deterrence or a punitive kind of law, but to have something in a more of a kind of a rehabilitation approach. And of course, the victim-centric, the restorative justice is also very, very important in current scenario, because since we have changed, globally the name has been changed of the terminology of the prisons to correctional administration. So what are we expecting from the correctional administration? Of course, we are expecting from the correctional administration the rehabilitation and reintegration of the person back into the society, so that the person doesn't get into that vicious circle. There's no recidivism again by that person. So we need to look into that, and all these things come back to access to justice, what Naveed was telling me to focus on, that it's very, very important for the lawyers which are there to provide, and for the state to provide access to justice to the victims, to provide a legal aid, a very efficient and timely legal aid to the, especially to the most vulnerable population of our country. That is very, very important. And my last point, I think, would be particularly on the sentencing guidelines, which has already been mentioned. But again, I would like to reiterate that, because that has been the concern not only now, but has been for many decades, that it's even for the judiciary, it's very, very important to have some kind of guidelines, sentencing guidelines, which need to be there for those offenses, which can be followed by them while they are, putting the people behind the bars, say for like 5 years or 10 years. There's a lot of scope. If minimum punishment, say, is 1 year and the maximum 10 years, there's a lot of scope in between that to put the person behind the bars, either for 5 or 10. So the sentencing guidelines is, I think, is the need of the hour, which needs to be done. But again, I would like to reiterate that as my organization, I come from United Nations Office on Drugs and Crime, and we mainly work with member states, with governments to do the capacity building of all the stakeholders of the criminal justice system, not only the law enforcement and the judiciary, but as well as of the communities, on the reformation of the criminal justice system, and to sensitize them on the laws and policies which are in line, that should be in line with the international standards, and also in line with the basic human rights which should be available to all, irrespective of anything. So I think that's it from me right now, and I would close here. Thank you. Thank you so much.
Thank you, Ms. Arya. Again, very important points across the spectrum as regards how access to justice needs to be improved, issues of sentencing guidelines, and that's come up again. I think I'll come back to that as a question for Justice Prakash. But before that, maybe we can start with Mr. Goel. It'll be great to understand from a person who's worked with prisons very closely. How do we need to reimagine prisons for a modern society, because it largely remains the same that was conceptualized perhaps 100 years ago? What should be our expectation from prisons going forward?
And Naveed, I'll disappoint you on that. You see, Palda, I'm sorry I'm not feeling particularly well after this. I'll need to leave. One thing is that I'll cut it short. My focus for an efficient criminal justice system is two things: efficiency and infrastructure. We don't have. Look at the courts, 5.1 crore cases pending. Judges per million people, 87 recommendation. There should be 50, we don't have 25. Right? So how do we meet the backlog? Look at the police. We don't have the requisite numbers recommended by the United Nations. How do you investigate so many cases? How do you provide justice? How do you ensure faster investigations? How do you not expect that there won't be any shortcuts during investigation by the police, and there won't be any shortcut methods taken to resolve crimes, or there won't be burking? Now coming to the prisons, look at the prisons. You have 131% overcrowding, right? And the kind of construction of prisons that is taking place in the country, it is negated by the number of the increased number of prisoners that get into the system. Of course, the courts are granting bail. If you look at the number of 2022, more than 53 lakh cases were registered, 58 lakh arrests made, and what is the number of people in prisons? Just 5.7 lakhs. So bail is being granted. Of course, there are issues. You find in anticipatory bail a high court hearing the case 20 times and asking the police to share their case diaries with the defense in anticipatory bail. You have issues. But my take is that for humane treatment of prisoners, it would be necessary that we construct more prisons. We have 806 districts in the country. What is the number of district jails? 428. The Honorable President also said that prisons are not a modern era construct. These should be demolished. There should not be more prisons. But if we find that with the burgeoning population, unemployment, criminality, juvenile crimes increasing, what do? You must provide good prisons. So I think I have, there was a mention about 3 months back, a DB in the Supreme Court was said that there should be more open prisons. In one of my articles, I have mentioned, milords, open prisons are no solution. 0.7% of the total prison population lives in open prisons. What about the remaining population? So it's not a, let's be realistic. We need infrastructure. We need more courts. We need more police. We need more prisons. If we want a good criminal justice system that delivers. Unless we ensure infrastructure, there can't be efficiency. We talk of reforms. Reforms of what? You think of reforms when you have provided the basic infrastructure. Here we are in a system where we are struggling for basic infrastructure. So let there be no talk of reform. First talk of strengthening the infrastructure. We have got the new criminal laws. It's a step in the right direction, but it is not a talisman that will wipe off all the backlogs, all the ills of the criminal justice system. But a progress has been made. Processes, the procedures and processes have been simplified. Let's hope, only time will tell how we go about it. But for that, all the agencies, the courts, the police, prosecution, and the correctional homes will have to come together and build greater infrastructure for delivery of justice to the common man. Thank you so much.
Thanks very much, Mr. Goyal. I think there are very important points, and it certainly needs to be seen, especially prison reforms, needs to be seen also as an infrastructure problem. And as you said, 95% of people who get into the prison do get bail. While some may get bail in a month, some get in 3 months, but that's a different issue altogether. But you can't expect the same number of prisons to keep up with the increasing crimes, increasing registration of offences or arrests. So there is a different way to look at this problem also, and I think infrastructure is one very important approach at looking at it. I have 2 questions, and then we can move on with audience questions. And this is because it came up a couple of times here on sentencing. This Prakash, how important is it for a judge to really, guiding the judge with such wide discretion? It's not just in the IPC or the BNS now, but across other legislations also. You have punishments that may be prescribed that may say anything between 3 years to life imprisonment or 7 years to life imprisonment. How important or how important is it for judges to really have that guidance in terms of sentencing guidelines?
I'll tell you what's practically happening in our courts. See, in our courts, I'm talking at the trial court level in thing. The prisoner, I'll tell you one small example. I'll start off with a small example. A prisoner, an accused, murders his wife, surrenders to the police. Next minute, the policeman knows that his confession is inadmissible. So what the policeman does this man comes penitent and surrenders. The policeman, what he does he's trained to take him to the village administrative officer, record a confession, bring him to the police station, record an FIR, and start the case. So the untruth in the system starts there. A fellow who is very penitent, who wants to, yes, I killed my wife for so and so reasons, I want to think, Over a period of time, survival instinct comes inside him and he starts, that penitence goes, that repentance goes. He fights the thing. The justification for him to fight is, I never went to VAO, I straight came and surrendered to you, you created a case as if I went and gave a confession, and that starts. Then the defense lawyer comes. Those days, when jury trial was there, the defense lawyers will have to convince the jury, act in such a manner that in Madras City we had jury trials. We had jury trials, 1955 we had jury trials. So the defense lawyers had an onerous thing to convince the jury. But post-jury system, what has happened is that the best defense lawyer is a lawyer who is able to protract the trial endlessly until the witnesses tire out or the accused dies. You take Jayalalitha's case. Jayalalitha could have easily conducted the trial there in Tamil Nadu, but it took 20 years for her. At the 20th year, you're going to tell Kunna, no, let us have sentencing policy. This lady is such a nice chief minister, one of the women chief ministers who won thrice Tamil Nadu. She's a thing. These are all the reforms she brought to Tamil Nadu. Kunna, Judge Kunna can't be swayed by all this. He would have got irritated by the 20 years of putting all sorts of things and things. So he sentenced her to 4.5 years jail. Go inside, remain. So trial judges are so tired of the tactics adopted by the defense that they ultimately throw sentencing to the wind and they just sentence you because you put them to so much of thing. I can tell you, my dear friends, 302 can never be made out in most of the cases. I can know that 304 part 1 or part 2 is made. It is the defense lawyers who make ordinary cases into 302 and get life sentence. A little amount of common sense, accept the certain parts, give an explanation, try to bring it into the exception. We judges are ready to sentencing, that thing is there. Only when you try to completely hide the whole pumpkin in a morsel of food, we judges get irritated. But a boss go live there and come, go to Supreme Court and get acquitted. So it is not that sentencing policy is not work out, it will not work, because practically this is what is happening in our trial courts.
Thank you, Justice Prakash. My other question was on what Mr. Bajpai had mentioned about over-criminalization, about the penal policy. Why do we criminalize and how do we criminalize? It's something that we are also trying to understand at VIDHI, trying to document the extent of criminal law in the country. And in fact, our work on union legislations tells us that the number of offenses go above 6,000 in just union laws, and that situation could be even worse with state laws. And this goes across a spectrum. We could have regulatory civil laws that use criminal provisions for compliances, and the issue also extends to, in terms of the arbitrariness in terms of prescription of punishment, 3 years punishment for cruelty and 3 years punishment for not giving documents on time. How do we, going forward, how do we really come up with those principles that really guide criminal lawmaking in the country to make it certain, to make it clear?
Yeah, so actually there are two very important issues, because one which was raised in this context, that while we have a very heightened expectations from the system, at the same time the capacity of the criminal justice system is not really matching to those requirements. And the India Justice Report has very clearly come out with those cold statistics and numbers. So I always believe that the criminal justice system is the operational part of criminal law. Criminal law is given effect by the criminal justice system. So this time, that's why I'm saying the reform has taken place in criminal law, but reform has not taken place in criminal justice institutions. That we must understand. Now the question that you are asking, actually, we were researching on this subject and I came to two very interesting conclusions. One is, in India, we do not have much understanding as to why we are punishing the people. One. Second, we do not have enough data as to whether punishment makes any difference, at least for the objective for which it is delivered. Absolutely, we don't know. But we continue to be very, very punitive society because we don't have anything other in our mind that could be delivered. You cannot reward a person if he does something wrongdoing. So immediately it comes to our mind that let this person be sentenced to jail. But while sending him in jail, there is no idea as to why are we sending him to the jail. You know, indeterminate sentencing was a system which were in existence till late 80s in the US. And that was very interesting system. So judge was not punishing the people with a definite years. Rather, it is left open. Prison institution and authorities will decide whether this person is now ready to be released or not. So the prisoner goes with the key of prison in his pocket. That was the idea. But as US also grew very, very penal because of the heinous crimes that were taking place, so they have also brought a parallel system which was too harsh. But whether harshness helps or not, that is something which we really don't know. But otherwise I'll say that the cruciality and the crisis of this system is also indicated by various numbers. So like India stands at number 78 as far as the World Justice Report Rule of Law Index is there, you know, almost. In the whole world, around 5 billion people are living outside of the protection of law. In India also, millions of people are not able to access the system. So if you see the Mark Galanter long back, he wrote an article and he was mentioning what actually Honorable Justice was mentioning, that if all the people start going to court for all the things that they have, the system will simply collapse. We are denying justice to many people, therefore we are saving the system to a great extent, because system doesn't have at the moment the total capacity to cater to the net requirements of the people. So that is very, very crucial. So I think we need to sort of look at more fundamental issues. The last thing that I would say about, which we have not discussed much, but India Justice Report, you know, states about the legal aid. You know, almost millions of people are living without any legal aid. So if you see the per capita availability of legal aid to the people, because of which they remain outside of the protection of law, is huge. So I think on ground a lot of work remains to be done if we really want to see these reforms in actuality or in a sense.
Bajpai. In the interest of time, I'll limit my questions and take a couple of questions from the audience, and we can close it by 5. Yeah, we have a question here. If you can have a mic there, please.
Good evening. I'm Kritika, a lecturer with OP General University. I teach themes basically around criminal justice. My question to you is to Seema ma'am. And ma'am, this is basically I'm dividing my question in 2 parts. When we talk of, firstly, alternatives to incarceration, as well as policies around criminalizing addiction, in the era globally and locally, when the focus so much is on taking a tough stand on crime, and as sir just mentioned, we are generally a punitive society. So in that background, where do these 2 ideas of incorporating in alternatives, implementing alternatives? It's not like we don't have alternatives to incarceration in legal provisions. The problem is with the practice. So where do we, and the same goes for decriminalizing addiction. Where is the reality on these 2? Thank you.
Yeah, in terms of alternatives to imprisonment, you are right that we do have alternatives to imprisonment and at all the stages of the criminal justice system, which needs to be implemented by different stakeholders. For example, at the pre-trial by the police, and at the trial by the judiciary, and at the post-trial by the prison authorities. So of course that they are, it's not that they are being fully implemented. We do agree with you, but of course there is more need to, that is what I was mentioning when I was talking about alternatives to imprisonment. There is a more need of doing a capacity building exercise with all these stakeholders and to guide them on how these alternatives to imprisonment or non-custodial measures in some offences can be implemented at their level itself. So this is where the capacity building and the training and the guidelines come in picture. And with regard to your second option, in the second question on addiction, of course, globally, that's an agreeable thing that everyone globally, most of the addiction is considered as a punitive thing. But however, there has been, it's not like that. Few of the countries have also been coming up and changing their laws and policies to moving more towards the rehabilitative and the reintegration approach and considering it as a disease. So it is, even in our society, I think it is very, very important to look from this perspective, that the use of drugs, the person who's using the drugs, merely a drug user, of course the person will be convicted, maybe not, I think more than 80% of the time the person is not convicted as a person who uses the drugs, but the person comes into the criminal justice system because of some other minor offense, because he or she needs money to use drugs. So it is, so we will have to navigate that complex thing and to see that if that person is, of course, a person who has been into drugs, how to put that person into the treatment thing and into the rehabilitation part. But again, as has been mentioned here by the esteemed panel, that infrastructure, the capacity, all these things are very valid things, not just in the criminal justice system, but also towards our health aspect also. So when we talk about that, how do you put the person into the, outside the criminal justice system and take the person to the treatment side, then again it is a valid point to see whether do we have so many drug treatment centers, and particularly for the people who are inside the closed settings, who are state's responsibility to provide them with this kind of facility. So these are the questions which also needs to be looked into in terms of when we are talking about infrastructure and the capacity, not only in terms of criminal justice system, as initially also I said that the criminal justice system also involves us. I'm not saying in the capacity of a lawyer. Us means that we, the people, are also the part of the criminal justice system. So everything is interrelated and interconnected. So we have to see at the same time, we have to see the capacity of our health system also to provide that kind of treatment to those people, which is very, very important. And even inside the prisons, it's not just about the person who is using drugs, but it also about the people who are inside the closed settings. They also need to be provided with the health facilities, and we are lacking in those things. Thank you. I hope I've answered your question.
Do we have any more questions? We have a question here and then there. Press it for a couple of seconds, it will work.
Good evening to the distinguished panel. I'm a research scholar from Jawaharlal Nehru University. I'm researching in science policy, focusing on the forensic science policies. So when we are talking about this reformation in the criminal justice system, one of the major aspects of criminal justice system is use of forensic science for judiciary. And I heard the distinguished panel's conversation, and even then, nobody has mentioned the reformation of the forensic science and services and infrastructure. Can I have some thoughts on that? Like, how can we overlook such a major system, and what could be done in order to reform the forensic science services?
Yeah, actually, this is very important because now the forensic scientists have been actually obligated to assist the police at the time of investigation. So there are two things. Number one, if you see the Forensic India report published by the National Law University, Delhi, it says that we are lacking at least there are 900 vacancies in the country. There are 32 CFSL, there are hundreds of state FSL, but still, so the kind of manpower we would require to cater to the requirement of crime scene management. So there actually I happen to make a recent suggestion which is being considered. I said you may not have the required number of forensic scientists to assist the police at the crime scene level. So what actually to be done at the crime scene level is not very serious science. There are 3-4 things which are very crucial at the crime scene investigation to be assisted by the forensic scientist to SHO or the Thana in charge. One is the preservation of crime scene for the purpose of the collection of exhibits. Now that thing can be handled. Second is the identification of physical exhibits to be collected. Third is the collection of the exhibits in a proper form following the standards, norms and protocol. And fourth is the preservation. Now to do this, it's not any very serious lab testing to be done at this stage. I have suggested like we have paralegal volunteers, who are supposed to assist the process. So I have given suggestion, there are a lot of forensic scientist students who are pursuing their master level. They can be considered as a, para-forensic science volunteers. To provide this basic assistance to the police, and they should be identified by the police station, then this job is possibly to be done. Because in 5 years or 10 years, sir will bear me out that we are not going to have a large number of forensic personnel in our country to assist this job. Second suggestion could be, you always have certain police personnel available. Why can't you train at least 1 or 2 constable level? They are always, these days, they are science graduate. Constabulary is very well educated. They form 80% of the police force. So if one of them could be trained in the basic forensic works which is required at the crime scene level, I think that would strengthen the capacity of the police significantly at the Thana level. So these can be, but at other level we have serious problems. I am not getting into the second thing which is very crucial, that we don't have the regulator of forensic science in our country. So regulation of forensic science, because you must be knowing the Anokhi Lal case, what happened. The DNA fiasco happened despite done by a very noted scientist. So why this happens? Because the following of the protocol, ensuring the regulatory requirement whether the exhibits are in a proper condition to be tested by the lab or not. So suppose a forensic scientist appear before the court and he says, sir, this is the DNA report or this is the ballistic report, the court in more likelihood is going to accept it. Nobody has that kind of competence, neither the defense lawyer nor the prosecution nor the judge, to question the nitty-gritty of the whole process, because that involves the scientific work. So I think we need to strengthen some of these gray areas in the forensic science in this country. Yes.
The thing is that I was a forensic scientist and investigated political science policy. So one more important thing that I saw was that the police is given too much of power in forensic in that sense, especially in collection and handling and investigation of the evidence when it comes to forensic cases related to forensic evidence. And there is not much power given to the forensic scientists who are working in the laboratory. They are only confined to the investigation, like especially the laboratory analysis, and just some assistance to the police while visiting the crimes. So why not reinforce the forensic science sector in general and give them a bit more power so that they can be, they can visit the crime scene themselves, kind of do that, that whole process that police is doing instead of them, the forensic scientists do. Because we have several graduates who are from forensic science and they have been,
Actually, your question again comes to the regulation of forensic work. Actually, the police is the preliminary investigation agency with all executive power provided under the law to investigate the scene of. There the forensic scientist cannot be given any parallel power to do that kind of work. Their work is confined to the forensic analysis of the exhibits submitted by the police. They can definitely question the state in which the exhibits have been received by the laboratory. Like for instance, I am saying, suppose viscera sample is furnished to the laboratory for testing. Now viscera should be in a position to be tested upon, because it has a duration factor, time factor, which is very important. Like blood sample has been collected, it is too soiled. So the collection of evidence by the police at the crime scene is very crucial in terms of actually, from the viewpoint of the forensic validity of all these things. So I think those sectors are required to be regulated. So like in UK, this entire work is regulated by a regulator. So there is a apex authority. In India, the Directorate of Forensic Science doesn't regulate the state lab in that way. I'm aware of that. So that is the problem. So now probably the government is considering the regulator. So once they will come, lot of things will be streamlined.
Thank you. Thank you. We're out of time now. We have one question that we can take, and we can close the discussion with that. Please be brief with your question. Thank you.
A very good evening to the panelists. My question is actually related to sentencing guidelines, or maybe prior to sentencing. It's more on under usage of plea bargaining, basically, like how lawyers can actually assist their client if she's accused in a crime, and then that he should, and they're sure that he's committed the crime or he's confessed. Then should they actually advise them to take plea bargaining, or what role can it play, or how the judges probably can assist in that?
Absolutely. You can really take it up and engage in plea bargaining. But the complication about plea bargaining is that what these people have done is the stigma still attaches. That is the problem. Why lawyers are putting spokes in this plea bargaining is, they are saying, unlike Probation of Offenders Act, this plea bargaining, the procedure is very cumbersome, and at the end of the day, even after you plea bargain, that the stigma seems to be attached to it. So lawyers say, okay, instead we'll turn the witness as hostile and get to a clean acquittal. That's what they assure. So anybody would prefer to join that side than go with you for a plea bargaining in the system. That's what I am saying. You delay the system, tire out the witness, and then try to get an acquittal.
Thank you, Justice Prakash. That was an enlightening discussion, and I would like to thank all the panelists for joining us. And I'd like to thank all of the audience. Thank you.
All the participants here.
Thank you. We have a small token of appreciation for all of you. And thank you to the audience also. Some of you have been sitting here since morning. And we can now leave for tea. There's high tea, and we'll reassemble back at 5:30 for our inaugural lecture on crime and punishment delivered by Mr. Kapil Sibal.